who may not file the form I-130. So you may not file the form I-130 for your adoptive parent or adopted child if the adoption took place after the child's 16th birthday, or if the child has not been in the legal custody and living with the parent for at least 2 years prior to the filing of these petitions. So there is some restrictions for adopted parent and adopted child. Okay, the adoption should take place, before the child gets 16 years old, and also you should at least live with the step parent or step child 2 years prior to the filing of the petitions. And as well, for a natural parent, you may not be able to file for your natural parent if you become citizen, because you get this citizenship, uh, you get permanent residence through adoptions. If you've been adopted and later on you become citizens, you cannot help your natural child get the green card. Also, stepchild, step parent as well as of stepchild. If the marriage that created the relationship took place after the child 18th birthday, this means if you get married after the child get 18 years old, you cannot file for your stepchild, as well as this stepchild cannot file for the step parent if the marriage that created the relationship took place, after the child get 18 years old. A spouse, okay, if your spouse were not both physically present at a marriage and the marriage was not consumed, you cannot file for your spouse. So how can you get married with someone if you were not present? Even the wife, no, I don't know. They are talking about marriage online. There is some specific situation where broker, make everything you get married. I don't know. You have to check this out. But mainly, if there is no proof that you were physically present at this place, so you never went to overseas, and you say you get married to a person, there is no proof, no ticket fly. So you cannot apply for the spouse. You have to be physically present to get married. Okay. A spouse, if you gain lawful permanent resident by virtue of prior marriage to a U.S. citizen or a lawful permanent resident, let's say you become you got your permanent residence because you married a U.S. citizen or a lawful permanent resident. So you cannot apply for your spouse, okay? If 5 years, you have to wait 5 years. Why there's these restrictions? They know there is some people, they already married, they just want to get the green card, they get married to a citizen or a lawful permanent in order to get the residency. After that, they get divorced and to marry to marry to the real wife. So they say at least you have to wait like 5 years since you become a lawful permanent resident. 5 years. So you're gonna wait. And if they discover, if they have informations that you get married just to get the permanent resident, after that you're gonna get married to your real spouse, you are in trouble. If they have information that you are just trying to evade, the immigration law. Okay, but at least you have to wait 5 years for that. They say also you have to, if you can establish by clear also a convincing evidence that the prior marriage through which you gain your immigrant status was not entered into the purpose of evading any provisions of the law. Okay, you just want to be sure that you are not trying to evade provisions of the law. They are talking about the prior marriage that you got with a U.S. citizen or a permanent resident. Okay, so if you can establish by clear convincing evidence, that's not something that you did on purpose just after that to come back to another person. Or let's say also this is really easy. If you married a lawful permanent resident or a U.S. citizen and your spouse die, Now it's really easy to get married, to apply for your new spouse. Okay, that's really easy. That really understandable. Since the person died, okay, you can get married. You don't have to wait 5 years in this case. Okay. Also, uh let's say if your spouse, the person you married, uh if you married your spouse while your spouse was subject to an exclusions, deportations, removal, rescission proceeding regarding his and her right to be admitted into or to remain in the United States, or while a decision in this proceeding was before any court or judicial review. Okay, so if you married while your spouse was in deportation, so you cannot apply for the spouse. But they say unless if you can prove by clear convincing evidence that the marriage is legal, valid where it took place, and that your spouse married in good faith, not for the purpose of procuring the admission of your spouse as an immigrant. Okay, in this case, even though your spouse was subject to deportation, removal, if there is clear evidence that the marriage was legal, you still can apply for this. But this is really great news, for people when their spouse have some immigration problem, deportation, removal. If you can have all the proof that your marriage was legal, you still can file for your spouse. Okay, or also if your spouse has lived outside of United States after the marriage for a period of at least 2 years, those case really you can still apply for the spouse even though the spouse was subject to removal or any proceeding that was before any a court on judicial review. Okay, they say also a now if your spouse has been legally determined that such you attempted conspire to enter into marriage for purpose of evading immigration law. So if they find out that you really get married, they have a proof that you really get married just to evade immigration law, you're not gonna get the green card. Mainly this is for the interview. If they ask you some questions, they may find out that you are lying. In this case, you cannot apply for your spouse. Okay, grandparent, you can apply. You can apply for grandparent, niece, uncle. You can apply for them, but your grandchild can be as a derivative. I told you that, your grandchild. So you're applying for your spouse, for your child, uh, son or daughter, and your daughter have a child that is under 21 years old. You're just gonna put the name of your grandchild as a derivative. Okay, so that's all for who may not apply for this form.